Namaskar viewers, hello and welcome to Sansad TV. I am Tina Jha, you're watching Perspective. Can the judiciary overrule the will of the people that is represented in Parliament? That's the question Vice President Jagdeep Dhankhar has posed amid the ongoing row over the process of appointment of judges. In a pointed response to the Supreme Court's 2015 verdict that struck down the National Judicial Appointments Commission Act, the Vice President said it was too serious an issue and the world does not know of any such instance when a law passed by Parliament that reflects the will of the people was undone by the Supreme Court. Ringing in a note of caution, the Vice President underlined that the judiciary cannot become the legislature or executive by denying or diminishing their powers, as any incursion by one organ into the domain of the other will upset the apple cart of governance. The Vice President's comments are a part of the larger debate over the separation of powers of each pillar of democracy, the executive, legislature and the judiciary. A distinguished panel of legal luminaries joins us to share their perspective on the show tonight. Pleased to welcome in the studio Justice Iqbal Ahmed Ansari, former Chief Justice, Patna High Court. Thank you, sir, for your time and welcome to Sansad TV. And joining us virtually is Mr. Harish Salve, Senior Advocate, Mr. P.K. Malhotra, former Secretary, Ministry of Law and Justice, Government of India. Thank you, gentlemen, for joining me on the program today. Justice Ansari, allow me to begin the program today with your perspective on what Vice President Jagdeep Dhankhar has aptly asked. In a democracy, the will of the people is supreme. Can the people's will, which is reflected in Parliament, be undone by the judiciary?
No, it's not the will of the people which is undone. But if this argument, what His Excellency, the Vice President of India has put, if it is extended logically, it will mean that any legislation which is passed either by a state legislature or by Parliament can never be struck down by the Supreme Court or by the High Court in their exercise of their power. If that be so, it is not that it has happened in India. In umpteen number of times, even in UK it has happened. The Supreme Court has struck down the law. The correctness of that can be always questioned. On that there is no reservation. But the power of the judiciary to strike down a law is something which is very well accepted. I don't know how this statement has been made, that the will of the people. Every legislation has the backing of the people because the Parliament represents the will of the people. Ordinarily it will be respected, but very reluctantly, if it need be, the judiciary has to strike it down.
Okay. Mr. Salve, coming to you for your opinion. The fact that the Supreme Court striking down a constitutional provision, is that something that's unheard of in any other part of the world?
From the question as you have framed about the power of a court to strike down the law, in the area of constitutional law, we all work with legal fictions. Parliament's legislation is, in theory, supposed to reflect the will of the people. In countries which provide for referenda, many times when a referendum is held, the so-called will of the people is rejected by the people. So it's not a plebiscite or it's not a referendum. When Parliament enacts, it is the will of the people expressed through the representatives of the people.
Right.
But then our constitution, which provides for this kind of parliamentary form of governance, does not create a parliament with unlimited powers like the British Parliament. If the UK Supreme Court has never struck down a law, it is because Parliament in the UK is supreme. Under the Indian Constitution, Article 13 limits the lawmaking power of Parliament, that they cannot make a law inconsistent with Part 3 of the Constitution. So, where the Constitution itself recognizes that Parliament cannot act contrary to Part 3 of the Constitution, the division of legislative powers between the states and the Union in the legislative lists, that gives rise to disputes about whether a law is within legislative competence. These are issues in which the Supreme Court has been made the final arbiter. Now, it does at times appear that a popular legislation is set at naught by the court, but that is the duty of the court. Yes, there has, in countries like the United States, where the US Supreme Court discovered judicial review, our Constitution expressly provides for it. In countries such as the United States, this conflict has arisen. President Roosevelt's time, when the New Deal legislation was struck down, they said you're overruling the will of the people, etc. So this kind of controversy has surfaced. Canadian Supreme Court has struck down laws. Australian High Court has struck down laws. The American Supreme Court has struck down laws. So the South African Supreme Court has struck down laws. So to say that it is unheard of that the court strikes down laws is completely wrong. Wherever there is limited government and the powers of a legislature are limited either by Part 3, like fundamental rights or some such limitations, or limited by the area of legislative competence, the court has struck down law and will continue to strike down law. So I think the question as formulated is wrong. In a limited government, the parliament does what it can do. The court finally is the arbiter of what are the limits on power of parliament acting under the constitution.
Okay, Mr. Malhotra, how do you look at the entire debate? Of course, it's been a subject matter of wider debate for decades about who is supreme, the legislature or the judiciary. But the fact that at the same time, the Indian Constitution also talks about certain limitations of the judiciary. And in that aspect, the Vice President has spoken about Article 145(3), which provides in explicit terms that interpretation of the Constitution when a substantial question of law is involved can be done by court. But nowhere it says that a provision can be run down. So is there a difference in how we are interpreting this particular law as well?
You see, taking the debate further from where Mr. Salve has left and answering your question, we have to look at the scheme of our Constitution. Please don't forget that all the three organs of the government, be it legislature, be it executive, be it judiciary, they derive their authority from the Constitution. And the Constitution has been framed by we the people of India. So we the people of India ourselves have given certain rights to the three organs of the government which are created under the Constitution, and each organ of the government has to function within the powers given to it under the Constitution. So debate has taken place in the past also a number of times, even on the Constitution Day itself, in various debates it has been said that each organ of the government has not to cross the Lakshman Rekha, which has been created by the Constitution itself. If we look at from that point of view, the question which we have framed, and as Mr. Salve has also said that maybe it is not correctly framed, judiciary probably cannot overrule the people's will because people's will is reflected in the representative of the people who are elected and come to the legislature, be it in the state legislature or in the parliament. But if the parliament or the state legislature, while exercising its power under the Constitution, exceeds its limit, the power of judicial review by the Constitution is given to the judiciary. And judiciary has to see whether the legislature, while making the law, has passed the law in accordance with the provision of the Constitution or not. If the law is not passed in accordance with the provision of the Constitution, then the Supreme Court has full power to declare a law unconstitutional. And it is not that it has happened for the past time. It has happened in the past on many occasions, starting from Shankari Prasad case in 1951, even in Keshananda Bharti or in Minerva Mill, we find that some of the constitutional provisions were struck down or interpreted in a way which expanded the scope of judicial review also.
Okay, so Justice Ansari, this having been said, because these remarks have been made by the Vice President in the context of the NJSC Act, for the benefit of our viewers, if we can understand what have been the concerns of the judiciary when it comes to the NJSC, what is it that they objected to because of which it was struck down in the first place?
No, it was struck down because of the fact that, you see, we have to go back to the history of this, not very long. NJSC was basically a kind of a scheme introduced by the government for the purpose of appointment of judges. Earlier also, in terms of the Constitution, President is supposed to be consulting the Chief Justice of India, that is the Chief Justice of the Supreme Court, while making the appointments for the High Court as also the Supreme Court. Now the question arose as to who will have the primacy of the opinion, because if the President supposing Chief Justice does not agree, will the President be still entitled to appoint? That is the question. So in that event, the primacy, according to the Supreme Court, lies with the Chief Justice of India. If he is, the consultation is that when I consult you, I can ignore your advice also or your suggestion. But here the Supreme Court says it means concurrence. He has to agree. If he does not agree, you can't make the appointments. Very simple. And that's according to the Supreme Court is the scheme of the Constitution. This interpretation may be correct, may not be correct, but so long as this interpretation remains valid, the striking down of the NJSC cannot be questioned. You can reintroduce in some form or another. Maybe it will be another controversy.
So I'll come back to that in just a bit. Whether whether these statements indicate that kind of a move by the government is something that I'll come back to you. But the fact that if not NJSC, Mr. Salve, the larger question here is also on the efficacy of the existing collegium system. So the rift has been out in the open, with successive governments and the judiciary over the transparency aspect in appointment of judges.
Let's just step back a moment and try and find out where this trouble started. The language of the Constitution is plain. It says the President shall appoint in consultation with the judiciary. In 1983, appointments made were challenged on the ground. They are not. Some of them were made without the concurrence of the judiciary. The Supreme Court said consultation means what it says, consultation, not concurrence. Let us also not forget that there were few appointments over which there were certain concerns, but by and large in the 50s, in the 60s, in the 70s, the system of consultation gave us all the giants who have sat on the bench of the Supreme Court, starting from judges like Gajendra Gadkar, Justice Bose, Justice, I'm not leaving any out, but Justice Shah, Justice Tuldapurkar, Chinapa Reddy, Sabyasachi Mukherjee. These were all sterling judges of strength who have built the constitutional jurisprudence of India. And they were all appointed by the executive. It's the post-coalition government where we realized political compromises started their incursion into appointment of judges. And that is where, when the issue came up, the Supreme Court said, relooking the law, consultation actually must mean concurrence, because that has been the practice, and that practice has become like a constitutional principle which now is binding. Well, that continued for a while till the collegium system's flaws became apparent. The author of the judgment of that time, late Chief Justice Verma himself said that, well, if I had known this is how it's going to be, I would have had a second look. You have to relook this interpretation. The NJSC came, and the NJSC tried to institutionalize the appointment of judges as it has been institutionalized in all of the civilized countries, all of the constitutional democracies. In nowhere in the world do judges appoint judges.
Right.
The NJSC was struck down by a judgment which, in my reading, is deeply flawed. The fundamental premise that any appointment by any body other than judges, or where the judges do not have the commanding absolute say, will destroy judicial independence is simply unacceptable. It is unacceptable because in the United Kingdom, judges don't appoint judges. And yet see the Brexit ruling, see the ruling against the government in power, which said, go back to Parliament. The US Supreme Court, can anybody say the US Supreme Court is not independent? Judges don't appoint judges. Canadian Supreme Court, Australian Supreme Court, South African Supreme Court. The example the late Mr. Siroy always used to give. The Conseil d'État, the highest court of France, where the executive appoints judges. It's been one of the boldest courts in the field of administrative law. So this fundamental premise that unless judges appoint judges, the basic structure of the constitution will be damaged because judicial independence will be compromised is not true. On a more practical level, the Supreme Court is not meant to be an institution of controversy. The Supreme Court hears arguments in open, the controversies which come before the court in open, after which their deliberations are quiet and behind closed doors all over the world. What they speak through then is their judgments. This kind of transparency has created chaos. Not only have judges now openly, publicly differed with each other, but look at what is going on. A petition was filed in Supreme Court under the Right to Information Act saying, tell us what was discussed in so-and-so collegium, because a former member of the collegium went and said all sorts of things in an interview. Right. And the court said, well, everything is not minuted. So they said, well, everything should be minuted. Now, can you imagine the kind of discussion which will happen? 5 of the Supreme Court judges are sitting and saying, Mr. X or Mr. Y, who's a sitting judge or a sitting chief justice of the High Court, let's bring him. And judge number 2 says, no, I don't like that fellow. I think he's too narrow-minded. Third fellow says, I've read his judgments, they are third rate. You want this coming out in public? You want this to be aired in the public? And this is what Supreme Court judges feel? And that man continues to function as a judge of the High Court? Will the litigant have faith in such a person? Look at appointment of judges to the High Court. Somebody says, make Mr. X a lawyer. Somebody else says, no, he's too arrogant. Don't make him a judge. You want this in public domain? So please, this is not the way to work this process. The collegium system has failed. The controversies which the court finds itself engulfed in show that the collegium system has failed. I think time has come for the government to strengthen the NJSC, maybe a broader based. And finally, I want to say one thing. This approach of the court that lay people cannot have a say in the appointment of judges is very wrong. And I gave this example in another interview. When I went for my interview to be appointed, then called Queen's Counsel, now I'm called King's Counsel. When I went for that, there was a panel of 3. There was 1 judge, 1 member of the bar, and 1 lay person. And this was only for a recognition where you're declared learned in the laws. They didn't think that you didn't need a layman on the panel. So we have to get past this aggrandizement of power. And I'm sorry, this has been judicial aggrandizement of power at the NJSC. The court striking down, I'm sorry to say, is a very flawed judgment. And it's time Parliament made a broader NJSC. And that comes up, somebody has to argue that this fundamental premise that unless judges appoint judges, the system will fail, this premise is wrong.
I think perhaps that's why this debate has lingered on for long, Mr. Malhotra, isn't it? Even if you look at the current row that's happening with the law minister questioning the entire procedure and the judiciary not willing to, have a fair and a transparent system. That perhaps is concerning for a country like ours. We claim to be the most vibrant and the largest democracy of the world, reflecting the will of the people. If we if one of the organs of our democracy is not transparent in terms of appointment of judges, and as Mr. Salve says, nowhere in the world are judges appointing fellow judges. So that perhaps makes it a matter of huge concern, isn't it?
Collegium system is again the creation of the judgments. It is not part of the constitution, I think, as is well known to everybody, I think, and it has been debated for a long time. But don't forget that Constitution is a living document and it has been interpreted by the Supreme Court from time to time to achieve the objectives enshrined in the preamble of the Constitution. Be that as it may, the fact, the collegium system came into existence when it was found that the executive to some extent is interfering in the appointment of judges. No doubt, by and large, the judges appointed were fair. They were excellent judges when they were appointed by the judiciary. But because there were certain vices which came into the appointment by the executive, this interpretation was given by the Supreme Court and the collegium system was created. Unfortunately, the same kind of vices have now come in the collegium system also. Therefore, in 2015, this law was amended and the National Judicial Appointment Commission was brought into existence by the Parliament. Now, if one thing which I feel, and I entirely agree with both Mr. Salve and Mr. Ansari are saying that probably this is a flawed system and probably needed to be reviewed, there is nothing which stops the Parliament to bring a new law. If certain deficiencies have been pointed out by the Supreme Court in the law earlier passed by the Parliament in 2015, those two should be looked into, and a new law should be passed by the parliament to see that there is a transparency in the appointment of judges. It has been repeatedly said that judges appoint judges happens only in India. If that is so, and it needs to be changed, it needs to be changed. It's not that the collegium, whatever judges have been appointed by the collegium are not good judges. Many good judges have been appointed, but there have been cases where there have been allegation of brotherhood, or people working in a particular chamber being appointed as judges of the High Court and Supreme Court, or belonging to a particular fraternity being appointed to the High Court and the Supreme Court. Probably there is a need to review that system. Whatever vices were there earlier in the appointment of judges by the executive, the same kind of vices have now come in appointment of judges by the collegium system, and probably with the passage of time, as I said, Constitution is a living document, and there is a time that the legislature should again pass a new law removing the deficiencies which have been pointed out by the Supreme Court in the earlier legislation.
Right.
So that there is transparency in the appointment of judges also.
Clearly, Justice Ansari, the onus now lies on the judiciary. The question is, after a period of 7 years, is the judiciary willing to accept a new law, perhaps, a broadened NJSC, as Mr. Salve suggested?
That test will be answered only when the matter comes before the Supreme Court. In case it comes ever after the new legislation, if any, is made by the parliament.
But the fact that, and which we've all discussed with Mr. Salve, with Mr. Malhotra as well, that perhaps the collegium has been bestowed with too much power, and that is where the questions on the entire procedure of appointment of judges...
Not too much of power, almost absolute power.
Exactly.
Mr. Salve and Mr. Malhotra, they are both I agree fully with them.
And that's the crux of the entire debate, that perhaps because there is too much power, absolute power in your words, the fact that it needs to be re-looked into. Is the judiciary prepared is again the question, because every time...
From the trend of the comments made by the Chief Justice of India, one after the other, doesn't look like that the judiciary is going to go back. But yes, the infirmities which are there in the collegium system itself, if the judiciary can think of ways and means of removing it, as Mr. Salve has very correctly said, one of the grounds of a dispute is the transparency in the collegium system, why a judge is ignored or why a judge is selected. And if a judge is ignored today, he will be again taken to the Supreme Court or at the High Court or anywhere after maybe a year, 6 months. So why was he ignored? No answer. Why has been selected?
Because we are talking of having more transparency and bringing in much more reforms, because that's clearly the need of the hour. Mr. Salve, after long, the current CJI happens to have a longer tenure than his predecessors. How hopeful are you that judicial reforms, things that we've spoken about, will see the light of the day?
See, I'm very clear about one thing. Judicial reforms are called for in the first instance at the level of the trial courts, the magistrates, the criminal courts, the civil courts, and at the level of the High Court. Supreme Court comes, there is pendency in the Supreme Court, but we have least of the problems. You can change every rule in the book. You can go rewriting your procedural laws. The problem of judicial reform is not going to be addressed. There are two critical areas which require repair. The judge per million ratio. How many judges per million are we going to have? And don't forget, in India, the government is the single largest litigant. Every decision, good, bad, or indifferent, is challenged by the government in some court or the other, where it goes against the government. In a situation like that, we should possibly have twice as many judges per million as compared to the United States or compared to United Kingdom, but we have a fraction. Secondly, even the existing vacancies in judicial office are not filled. Why? Because the salaries and the conditions of work are abysmally low. Now, yes, there are a lot of people who are happy to make a sacrifice and go and work as judges, but it doesn't work that way. Thirdly, we are stuck with this idea that you must have members of the bar and they give exams and then they become judges. Why not we look at what certain other countries have? For example, have a college, have a law course where you train from day one to be a judge. You pass that exam, You pass out as a member, a potential member of the judiciary, and then you apply for a judge's job or become a lawyer. But you are trained in college as to how to be a judge. So these are the kind of things which we need to do. We need to increase the number of judges. We need to invest heavily in our judicial infrastructure. Our judges must have the benefit of digitalization. But if you go and see the way our judges have to work, you will not say, why is there so much pendency? You will say, how do they manage to dispose of what they do?
Right. Mr. Malhotra, I'll take one last comment from you. It's important for a democracy like India to ensure that all of these pillars, strictly adhere to the powers and functions that have been bestowed to them by the Constitution, the right balance of power, and to ensure that they do not overreach into each other's domain. Is that even practically possible? Because we've seen in recent years overreaching of domains by both the legislature and the judiciary. That is something that has led to this kind of conflict that we are witnessing now. And that leads to the logjam ultimately impacting the people who are at the center of the democracy that we claim.
Tina, as you yourself have said, that this is of recent origin. The Constitution has been working from 1950 onward. This kind of imbalance was not seen earlier. It is only when one organ starts overreach over the powers of the other organ, this kind of difficulty arises. I think so far as judicial reforms are concerned, it is an ongoing process. Reforms have been done. If you look at the functioning of the judiciary, what it was in 50s, 60s, or 70s, and what it is today, the use of technology, the number of judges have also increased. Of course, the ratio is not as appreciable as it is in the developed world. And I remember recently when the present Chief Justice was appointed, and he was welcomed by the Supreme Court Bar Association in his speech, he has said if you have to bring the reform on the judiciary, reform has to begin at the district level, lower court, because most of the people, they approach the court at that level. I mean, Supreme Court and High Court, the number of percentage of people who are coming to the Supreme Court or High Court is very, very low. And those who can really afford, they are coming. But if justice delivery is to be improved, the improvement has to be brought at the lower judiciary level, where judges need to be increased. In better infrastructure is needed. Of course, it is being done, but it is not at the appreciable level. I think probably more need to be done in that direction, and it can be done with cooperation of the government only. Funds have been provided in the past. There are proper utilization of funds, because I remember when I was in the government and I have seen that in one of the cases where the Finance Commission has allotted some money to the judiciary, the whole money was not spent by it in spite of the fact that the funds were there. But the kind of infrastructure improvement which should have been brought in the lower judiciary could not be brought because they were not in a position to fulfill some of the conditions for getting those funds. So I think proper coordination among all the three organs of the government is also equally important.
Absolutely. So I think the deeper underlying message is the kind of coordination that the three pillars of democracy have to ensure, and also at the same time strictly adhere to the kind of powers that they have been bestowed with, because that's important for our democracy. That having been said, I'll have to wind up the program. Thank you, gentlemen, for joining us on this edition of Perspective, sharing your thoughts with us and our viewers. Absolute pleasure to have you three on the program today. And viewers, thank you very much for your time as well. I'll see you same time tomorrow. Take good care of yourselves and keep watching Sansad TV.